He's called from Exeter and Steve in Hayes to carry on our conversation about the release of the rapist John Worboys. He's not released yet, and David Gauke, in that statement he gave to the Commons, said he won't be released until the conditions of his licence have been agreed. Johnny, how do you read this situation? There's all kinds of ways into it.
Yeah, hi Sheila. Well, there are 3 points that I wanted to make. The first one was that David Gauke is right, that the Probation Service is an independent arm and must be seen to be independent, left to be independent. So, you know, he oversees, he's at the helm of the Ministry of Justice, but he obviously cannot interfere and micromanage every decision that they make. They follow sentencing guidelines and they follow a due process, and as long as they tick those boxes, and, you know, I know it sounds quite formalistic considering what we're discussing, you know, from a moral point of view, but as long as they follow the right process, he must leave them to do their job, and he must leave them to be independent. The second thing is, judicial review is an incredibly difficult thing to bring to court. The first thing you need to do, the first hurdle you have to overcome is standing. You have to prove that you have standing, that your case has merits. And, you know, and that's quite strict. So we have to bear in mind that judicial review is not an appeal. It's not an appeal of the decision, as you said earlier on. It's a review of the process that was followed. You know, and that's a very fine distinction. So as long as the process was followed, as long as there were certain grounds like illegality is one of them, so that the public, the public. Well,
I would argue it can be both of those things. You're right to say what you said, but I still think, you know, the process can be followed, and it can be followed inadequately, or it can be followed and a wrong decision can still be made for all kinds of reasons. I think both need. If you're going to revisit them, revisit both.
No, it still needs to be within certain very.
Well, I know it does in law. I'm back to the moral question, not the law,
right,
the legal question.
Is another question completely.
Yes, it is.
The moral question is a separate question completely. You know, he should. You know, there are people who could reasonably say that he should never come out. Whether that's right or wrong, we reasonably understand that it's a reasonable opinion to have on someone that does something as horrible as that. You know, one crime he's been
bad enough,
for, you know, the worst one. You know, that's enough. But we are talking about the law. And the third point that I wanted to make was that Sadiq Khan is a lawyer. He knows these things. He knows that there are very.
Is he politicking?
He absolutely. He's what's the
is it virtue signalling?
Virtue signalling, yeah. Sorry, it escaped me for a moment. Yeah, he's virtue.
I could feel that's what you were grasping for.
Yeah, absolutely. He's virtue signalling, and you know, and it's an exercise in political public relations. He wants to be seen to be and I'm not saying that he doesn't have the same moral convictions that we've just expressed. You know, I'm not saying that at all. He likely does, but he's a lawyer. He knows that this is weak ground. But having said that, lawyers go to court every single day on weak grounds and win. So, you know, it's certainly not absolute.
I wonder how long it needs to take. I don't know what happens next, but I wonder how long it needs to take to lift the lid on the parole board's decision, so that we might see it, and we might look at the detail of it and say, oh, we can actually, you know, we can relax now. This man clearly isn't a danger to anybody anymore. Maybe he's terminally ill. Maybe he's, you know, for some kind of physical reason he's no longer. I don't know. Well, but I wonder how long it might take before they could lift the lid on that.
They have to lift the lid for anybody to question the grounds, to question the things that were considered and the things that were not considered. You know, so the lid has to be lifted. You're absolutely right. But I'm a bit anxious that when you say that we should be the ones who would.
When by we, I mean the nation. I mean the correct authorities,
Sure, but the nation's always going to have an opinion, but that doesn't mean that we can make any accurate decisions on the legal aspects of this, and that is what we're talking about here.
No, I know, but sorry, to be clear, when I said we, I meant, you know, David Gauke has said the government is going to review the transparency factor. The parole board chair, Nick Hardwick, and in that statement that we got from the board itself a few moments ago, has made it clear it wants more transparency of the work that it does, maybe so that we have faith in them. If they feel they're doing a job and people think they're actually stitching us up, it doesn't do them any favours either. And there clearly is a feeling amongst victims that this is a stitch up.
Yeah.
And so if it really isn't, and let's say it isn't, if it isn't, Nick Hardwick and his colleagues probably do want to say, look, this is why the man is no longer a threat. He is precisely and definitively no longer a threat because A, B, C, and D. That's what's needed. Yeah. That's what's needed here.
What my question would be, what would be the reason for a stitch up or grounds for a stitch up?
I don't know. I mean,
negligence of some kind.
Attitude, maybe attitude. I don't know. We've seen it before. I mean, it's great when the system works, but we see time and again that it doesn't, don't we?
Yeah, but we're not talking about somebody not being locked away who should have been locked away. He was, and as far as the system is concerned, as far as our judicial system is concerned, he was locked away for, within the range of sentencing that
was available, yeah.
Yeah, that was available. So perhaps the question then, if the question remains, perhaps the question goes to somebody else, to another door. Yeah, absolutely.
Thank you, Johnny.
Absolutely.
Good to talk to you. Good call. Thank you very much indeed. Good to talk to you. Steve in Hayes, hello.
Hi there. The previous callers virtually covered everything I wanted to say, really. Just to reinforce it, I work for a government regulator and we're subject to judicial reviews all the time in our decisions. And the fundamental is that seems to be forgotten, which has been covered just a moment ago, is that our decisions can't be questioned by the judicial review. It is only if we've reached that decision through going through the wrong process. So,
sorry, you're speaking as though you're a member of the Parole Board, are you?
No.
Oh, sorry, I just wondered if you were by the...
No, not at all. I just said I work for a government regulator. Sorry, a regulator.
Apologies.
And we're subject to judicial review in the decisions we make. And the fundamental is that the judicial review will not review whether the decision is right or not. The decision will stand if the process has been followed. That is how it is. And as what Sadiq Khan is doing as a lawyer, the only grounds on which he can go through a judicial review would be to say that he thinks the process hasn't been followed. And in this case, it could be, for instance, and I don't know the details, if, for instance, the Parole Board are required to consult with victims and didn't, or they're required to notify victims and didn't. Those kind of things would cause maybe judicial review to be successful. But if the process has been completely followed, then the decision that's been made can't be overturned. And that's how the law works. I'm not a lawyer, but that's how it works. And I'm really surprised that so many people, and that's probably the reasons why the government has not gone through it, because perhaps because
procedurally it's sound.
It could be that they have looked at this and see there's nothing, they can't see any grounds on which the procedure that the Parole Board is supposed to follow has been breached, and therefore they would have no grounds for going ahead with it.
Mm-hmm.
Again, it doesn't matter about the morality of the decision, whether it's right or wrong or anything like that. That's the process, and that's how the law works. And countless people get off on very, very serious crimes on a technicality, maybe because, for instance, huge amounts of evidence has been collected, but it was done illegally by the police, in which case all of that evidence is non-admissible and that person will walk free. That's how the law works.
And as to the transparency of the decision once it's made procedurally soundly, do you think it is time, as many people do, to open that up?
Well, it could be, but this is the kind of thing where you don't want one case to make a law. It might be the precipitant that makes people look at it. But if the Parole Board, for instance, the law says that they're not allowed to give that decision out and give the reasons for it, then that's the way it is until the government changes the law. It's as simple as that.
Okay, Steve, thank you for your call. Thanks very much indeed. 2 strong calls there at the end. Thanks, Steve in Hayes. Let me read a quick text before we go to the news at 2.